free consent. Consent means the other party is agreeing to that particular contract. So consent should not be influenced by anyone. It should be completely free from any kind of coercion, mistake, fraud, or any kind of other effects. So what is free consent? Section 13 of the Act defines that two or more persons are said to consent when they agree upon the same thing in the same sense. There should be consensus ad idem. Consent needs to be free in order to constitute a valid contract. Section 14 of the Act defines free consent and states, consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, and mistake. So what is this coercion, undue influence, fraud, misrepresentation, and mistake? Let's have a look. Coercion. In layman's talk, if we say coercion is nothing but the action or a practice of persuading somebody to do something by using force. Section 15 of the Act defines coercion and it provides following ingredients. Committing or threatening to commit any act forbidden by the law or Indian Penal Code. Means you are committing any act which is a punishable offense as per IPC, or you are threatening to commit any kind of act which is prohibited by law. The unlawful detaining or threatening to retain any property to the prejudice of any person. So unlawfully you are detaining some kind of property or you are threatening to detain a kind of property with the intention of causing any person to enter into an agreement. So what are the effects of coercion? Coercion, no doubt, vitiates free consent. The party or parties whose consent is taken under coercion gets a right to avoid the contract if he so likes. However, if the aggrieved party has received any benefits under the contract which he is avoiding on the basis of coercion, he has to return that benefit to the other party or parties. In Chikkam Amiraju versus Chikkam Sheshmanna, it was held that the threat of suicide amounts to coercion under Section 15 and the release deed was hence voidable. So threat to commit suicide was considered coercion in that particular case. Next is undue influence. What is influence? Influence means the capacity to have an effect on the character, development or behavior of someone or something. And undue influence is the act by which a person is induced to act otherwise than by their own free will or without adequate attention to the consequences. Any undue influence to gain consent will be vitiating the free consent of the parties. Such consent will make the contract voidable at the option of the party whose consent was so obtained. Section 16 subclause 1 lays down the following ingredients. The relations subsisting between the parties are such that one of the parties in a position to dominate the other. He uses that particular position to obtain an unfair advantage over the other. Section 16 subclause 2 provides that a person is deemed to be in a position to dominate the will of another, where he holds a real or apparent authority over the other, where he stands in a fiduciary relation to the other. A fiduciary relation is a trust relationship which exists between a doctor and a patient, husband and wife, where he makes a contract with a person whose mental capacity is temporarily or permanently affected by reason of age, illness, or mental or bodily distress, or for example you can call minor or infant. Section 16 subclause 3 provides that where a person who is in a position to dominate the will of another enters into a contract with him and the transaction appears on the face of it to be unconscionable, the burden of proving that undue influence was not induced on weaker party will be on the person who is in a dominant position. Contracts with the Pardanashi women. What about these kind of contracts? So in this particular case of Annapurna Barak Devi versus Srimati Inda Beva, it was held that when a person enters into a contract with a Pardanashi or illiterate women, the burden of proof is upon such person to prove that the terms of the contract were understandable and that she was capable of rendering an independent opinion after having understood the document. What are the effects of undue influence? So section 19 clause A speaks about the same. Such contracts voidable and can be rescinded by the parties whose consent had been vitiated by undue influence. The court can set aside such contract either absolutely or where the weaker party has enjoyed some benefit under the terms of the contract, then upon just and equitable terms, the court may deem fit. Next is misrepresentation. Means you are misrepresenting the facts or misstatement of facts or facts that are material to the contract by which one man misleads the another to his injury and consequently vitiates the free consent of the parties. Means the facts which are as it is, in spite of representing as they are, you are just making misstatement with regard to them to change their meaning. Section 18 of the Act defines misrepresentation and provides some ingredients for the same. Making of unwarranted statements which are not true, although the person making it believes to be true. So making false statement, first of all. There is a breach of duty whereby the person making a false statement gains some advantage. The person who's making the false statement has some advantage, or by the making of this particular false statement will have some advantage. Causing a party of an agreement to make a mistake as to the substance of the thing which is the subject matter of the agreement. Now, subject matter of the agreement is the soul of that particular agreement, and causing a party of an agreement to make a mistake as to the subject matter of that particular agreement. What are the effects of misrepresentation? If consent was caused by misrepresentation or by silence, where the truth can't be discovered with ordinary diligence, the party will be guilty of misrepresentation. But if the party whose consent was so caused had the means of discovering the truth with ordinary diligence, then the contract will not be voidable at the option of either party. Means if they can discover the truth by their ordinary diligence, then you can't plead misrepresentation. In the case of Balraj Chipper versus New Oakland Industrial Development Authority, it was held that if the party had the means of discovering the truth with the ordinary diligence, the party can't complain about misrepresentation. Next we have is fraud, which can vitiate free consent. Fraud is an act or cause of deception, cheating, and intentional concealment of fact, omission, or perversion of truth to gain an unlawful or unfair advantage, inducing another to part with some valuable item or surrender a legal right, or inflict injury in some manner. A false statement of facts made knowingly is called fraud and vitiates the contract, and such a contract is voidable at the option of the aggrieved party. Unintentional or innocent misrepresentation is not fraud, but the person making the representation believes it to be true. Thus, where a false statement is made intentionally with the knowledge that it is false, with a view to deceive the other and thereby inducing him into entering the contract, it is known as fraud. Section 17 of the Act defines it. Fraud means and includes any of the following acts committed by a party to contract with intent to deceive another party or to induce him to enter into the contract. First, the suggestion or as to the fact of that which is not true, means you're suggesting regarding those facts which are not true. The active concealment of a fact by one having knowledge or belief of the fact. After having complete knowledge of the fact, you are just hiding them. A promise made without an intention of performing. Without an intention of fulfilling, you're just making a false promise. Any other act fitted to deceive. Doing any act to cheat. Any such act or commission as the law specifically declared to be fraudulent. Any act which has been declared specifically by the law to be fraud. S.P. Changalwar Rayanaidu versus Jagannath. In the words of the Honorable Supreme Court, a fraud is an act of deliberate deception with the design of securing something by taking unfair advantage of another. It is a deception in order to gain by another's loss. It is a cheating intended to get an advantage. But mere silence is not fraud. But as per the explanation given by section 17, mere silence does not amount to fraud even if such concealment is likely to affect the willingness of a person to enter into a contract. But there are certain situations where keeping silence would amount to fraud. Situation number 1, duty to speak. There are certain contracts that are contracts of absolute good faith. In such contracts, it's the duty of the person to disclose all the material facts to the contract. For example, the contract of insurance. If you are taking any medical insurance, then you have to disclose all kind of your medical history. Second is deceptive silence. Sometimes silence amounts to speech. A person who keeps silence knowing well that his silence is going to be deceptive is guilty of fraud. Change of circumstances. Sometimes a representation made is true when made, but subsequently due to a change in circumstances becomes false. It's the duty of a person making representation to communicate the change in circumstances to another person. So if there is any kind of change in circumstances, so the other person is under the duty to inform the party. The next element is mistake, which can vitiate free consent. So as per section 20 of the Act, a contract is declared to be void when a mistake is caused by both the parties, that bilateral mistake, which violates the essentials to an agreement. Now, over here we are talking about a bilateral mistake. Take an example. A made agreement with B to sell the goods and the agreement was done. A was not aware of the fact that the goods are perished due to some reason. In this case, the contract would be void because the basis on which the contract was made does not even exist. Next, mistake of law. People should have minimum knowledge about the law. They should be aware about the fact that which act they should refrain from doing and which they ought to do. And there would be no remedy provided or excused under the fact of mistake of law. In the case of Ramchandra versus Ganesh Chandra, it was seen that the complainant entered into an agreement of lease of coal mining with the respondent. As per the agreement, the complainant made payment in advances to the respondent. But the Privy Council and the decision of the Calcutta High Court questioned the understanding of the law between the parties. Thus, the complainant refused to continue with the contract and sued the respondent for the refund. Taking a precedent of Cooper versus Phibbs case, it was held that the complainant would be entitled with the refund paid by him. When there is a bilateral mistake causing the contract to be void, it is subjected to a mistake of fact and not to a mistake of law. So now one thing is clear, that bilateral mistake is connected with mistake of fact and not with mistake of law. When there is a misunderstanding between the parties or omission of fact which leads to the mistake is said to be a mistake of fact. Now bilateral means from the both sides of the parties. When both the parties commit a mistake in the contract under the mistake of fact, the mistake is considered as a bilateral mistake. This happens due to the lack of meeting of minds, which is again an essential element to constitute free consent. Thus, the contract is made void. There are two types of mistakes: mutual mistake or common mistake. Take an example. A agrees to sell his car to B, but it was found that the car was stolen and he was not aware about the fact while making the agreement. Thus, this contract would be considered void because the subject matter doesn't exist. Bilateral mistake as to the subject matter. So it depends first of all on the existence of subject matter. When both parties have made an agreement on a subject matter which does not even exist, then the contract would be considered void. Second, quality of the subject matter. When both the parties have made an agreement on a subject matter and it is found that the quality differs from the one which was mentioned. But in the case of bilateral mistake, the contract would be considered void. Third, identity of subject matter. When both the parties have made an agreement on the identity of subject matter and it differs, then the contract ceases to be void. Next is mistake as to the possibility of performing the contract. Whether the contract will be possible to be performed in future or not. So, with regard to possibility, we have two kinds: physical impossibility and legal impossibility. Physical impossibility, when an agreement is made and it is found that the subject matter is not available anymore, then it becomes impossible for the parties to execute their part of the obligation. This is considered to be physical impossibility to perform. Thus, the contract becomes void. A made agreement with B to sell the goods and the agreement was done. A was not aware about the fact that the goods were perished due to some reason. In this case, the contract would be void because the basis on which the contract was made does not even exist. Next is legal impossibility. When an agreement is done between two, but it is seen that the war arises between the countries, thus the contract between the countries becomes legally impossible to be carried out. So this is legal impossibility. A. One country enters into contract with B, another country, to export petroleum with an agreement for 20 years. But after 10 years, it was seen that there was a situation of war arising. Thus, all the internal exports were stopped. In this case, A is legally bound to end the contract with B. Thank you. That's all for this particular session with regard to free consent.